2015 petition 7. This is at serial number 5. This I have submitted that this is a matter relating to clients. And roster is
कौन सी serial number है?
serial number 5. WBC 5127 of 2006.
Note करेंगे. Are you a further respondent?
No, I am for the petitioner.
The learned counsel for the petitioner submits that
The roster is here.
as per the roster, the matter is to be decided by Honorable Division Bench. Office is directed to place this case before the Honorable Chief Justice on the administrative side for appropriate office.
Kindly see whether it is finding them.
आप बोल रहे हैं सर काफी
And I have to say,
इतना नहीं सर आप क्या सोच रहे हैं
then I have to say so straight.
आप लोग जो बोलते हैं हम उसको सच ही मानते हैं unless I find it from the record to be incorrect. So और आपसे तो बिल्कुल ही नहीं हम सोचते हैं ऐसा. हाँ आपका है मेंशन हुआ था ना आपका है मैटर.
But it is not correct but there was an order for issuance of notice on respondent 12C and 12D.
Yes.
There was an order to either file a requisite or in alternative file substituted service. But requisites have been filed on 6/12/2025 in civil division. Civil division. And that requisite have been filed. There is a report that undelivered notice of respondent 12C and 12D is due with report not reached.
ये तो पहले भी आया था ना. आप सेम एड्रेस पे भेजते जा रहे हैं. नहीं एक ही बात है ना. मतलब why are you doing this? Present and correct address पे होता है ना. If you are sending it at the same address.
But हम best report हम application file करते थे next week then हम substituted service लिए क्या paper publication थे.
तो सिविल डिवीजन सेकंड अपील में नोट है वो जो
Second appeal.
सेकंड अपील में ऑर्डर डेटेड 7th of October 25 notice issued to respond number 8, 9, 11 to speed post deliver. Respond number 10 is dead. No step has been taken. Then respond number 1 to 7, 20, Roman 3, 22 to 25, 26A, 22, 26D, 27 to 31 have already appeared. I have appeared on their behalf. Service of notice effected on 21 and 22. Service notice on respond of 15, 16, 17A to 17C, 19 and 22. Accepted validly. Respond number 18 has been.
सिर्फ 8, 9 and 11 से मतलब है ना. Respondent number 10 was reported dead. When?
Yes.
When was he reported dead?
Yes. But then order to that effect on 7/10/2025.
Seven 10/25 को respondent number
But
हाँ
since
has been reported dead.
order dated 7/10/25 respondent number 10 is dead. However, no steps have been taken as per the CIS report. But I will.
So the proceeding has abated. Let's take it. ऐसे number.
So we file.
Just a moment. Respondent number 10 कौन है?
For respondent number 10 is defendant respondent. Shahida Khan.
Respondent number 10 has expired and this fact has been recorded in order dated 7th of October 2025 also. Apparently the proceeding has abated so far as respondent number 10 is concerned. Notices were issued upon respondent number 8, 9 and 11. The same has been shown as delivered. बाकी से तो कोई मतलब नहीं है.
बाकी अपीयर है
जो भी है वो तो पुराना. वो तो पुराना सर्विस है।
Accepted validly.
18 has been deleted. Why 18 was deleted?
But expunge
Why?
वो लीगल है
अच्छा,
उस पर नहीं
That is the
हो गया?
that is the-
अब तो इसका सर्विस हो गया कंप्लीट।
ये इस पे कंप्लीट हो गया, बट जो दूसरा सिविल
ये हो गया, ये ऐसे में है। सिविल डिवीजन में बताइए।
और वही 12 सी नोट उस पे सर्विस रिपोर्ट है कि हाँ आपको सर्विंग ट्रैक नहीं हुआ, नॉट ट्रेस।
12C है सिर्फ।
12C and 12D. Note we keep it next week. I will file an application 520. So for paper publication.
लास्ट नोन एड्रेस है बिहार का।
हाँ, तो एड्रेस नोट बिहार पटना या सावन ट्रैक।
In civil division number 26 of 2010, the undelivered notice of respond number 12C and 12D has again been received with the report not traced. Counsel for the appellant has submitted that he has no option but to file a petition seeking substituted service of notice. Post on next Thursday. In supplementary list. बोल के करा लेंगे।
हाँ,
सर आपका आज रिट पिटीशन भी है जो हमको लिखाना है और दो लाइन।
सिर्फ एक चीज जो को पॉइंट आउट करते हुए हाथी that in so far admission is there and page 25
अभी वो फर्स्ट अपील का हियरिंग होना था, वेयर आर दे? यस मैडम, आर यू देयर? हाँ, अभी हम फर्स्ट अपील का पहले हियरिंग करेंगे।
कोई बात
पास ओवर? ओके, आप आइए। यू हैव प्रिपेयर्ड सम नोट? नॉट येट। आपका सबमिशन रिकॉर्ड कर लेते हैं।
we did not
Just a moment. This is your. You were not there yesterday, so I would like to hear you.
But one thing what I have been told that there is a from my side I will say that there is a confusion whether 49(5) it prescribes a period of 12 years and 71A which does not have a period as in 49(5). 71A can be invoked on the instance of the Raiya. My submission is 49(5) is a provision which acts on a separate sphere. 49(5) it starts with the word 49(5).
आप कल तो थे नहीं, मतलब ये थोड़ी है कि आप एकदम डिनोवो शुरू हो जाइएगा।
डिनोवो नहीं शुरू हो रहा
फिर
है,
क्या?
एक बस हम लॉ प्रोविजन में हम सिर्फ एक बात बोल रहे
ये
हैं।
सारी बातें कल हम लोग कर चुके हैं, इसीलिए आपसे बोल रहे हैं।
49(5) are not that powers.
Two judgments he has cited. What do you have to say to those two judgments?
What?
आपको नहीं पता है, भाई को दिखा दो।
49(5) जो है स्टेट गवर्नमेंट का पावर है, स्टार्ट विद स्टेट गवर्नमेंट नॉट विद द डिप्टी कमिश्नर।
That's right.
12 years जो है वो स्टेट
You see, the allegation is that fraudulently and by misrepresentation
पॉटरी का फैक्ट करने के लिए उनको ट्रांसफर हुआ है
और वो उसको
उसमें वो एक
नहीं, एलिगेशन ये है कि फ्रॉडुलेंटली पैसा करके ट्रांसफर कराया गया।
फ्रॉड
फर्क है ना दोनों में। एक होता है कि ट्रांसफर होने के बाद इट इज बीइंग यूटिलाइज्ड फॉर समथिंग एल्स। अगर ट्रांसफर होने के बाद इट इज बीइंग यूटिलाइज्ड फॉर समथिंग एल्स, द रेमेडी इज समथिंग एल्स बिकॉज इट विल डिपेंड अपॉन द टर्म्स एंड कंडीशंस ऑफ द ट्रांसफर। अगर ट्रांसफर में टर्म्स एंड कंडीशंस में लिखा होगा दैट द ट्रांसफर विल स्टैंड कैंसिल्ड, देन द अथॉरिटीज कैन टेक स्टेप्स एज पर
49 में जो ट्रांसफर होता है दैट इज फॉर अ पर्पस
और पर्पस डेविएट होने से क्या हो?
पर्पस डेविएट होने से 49(5) का कॉन्सिक्वेंसेस होता है, अगर पर्पस डेविएट होता है तो। और फ्रॉड अगर तब 71 है,
उसमें भी तो फ्रॉड लिखा है, फ्रॉड एंड मिसरिप्रेजेंटेशन 49(5) में।
49(5) का मतलब वही हम बोल रहे थे, सिर्फ एक बार हम दोनों प्रोविजन का स्टार्ट का 3 लाइन दोनों प्रोविजन का पढ़ देते हैं बस, और जो हम कहना चाह रहे हैं बस वो क्या कह देते हैं। 49(5) 49(5) says the permission is granted by the deputy commissioner, but 49(5) says the state government may at any time within a period of 12 years from the date from which written consent is given by deputy commissioner. So a period of 12 years is specified for the state government to initiate a proceeding within a period of 12 years for annulment of transfer. 49(5) में ये
और आगे नहीं पढ़िएगा, फ्रॉड एंड मिसरिप्रेजेंटेशन भी
फ्रॉड यहाँ है, बट बाय दिस सेक्शन 71A का एप्लीकेशन बार नहीं है। 71A बहुत ब्रॉड है और वो सेक्शन बाद में लाया गया था, वो 86 का अमेंडमेंट।
वो जो जजमेंट से साइट किए हैं उसका हम क्या करें? ओवररूल कर दें। You see, I'll tell you one thing. I will protect your rights also. Because the proceeding was initiated by filing an application within 12 years. पहला बात। दूसरा बात, people were fighting it on the point of jurisdiction. High Court में भी आया था ये मैटर, jurisdiction point को threshold में decide करना, right? जब jurisdiction को threshold में decide करना था, and ultimately we are on the point of jurisdiction now again, correct? Then under such circumstances, the period during which the proceeding remained pending, I will observe that will stand excluded, and if the appropriate government or the lawyer, they have their right to proceed under section 49. यही, क्योंकि वो तो हमको एक्सक्लूड करना पड़ेगा, नहीं तो वो प्रोसीडिंग टाइम आउट हो जाएगा, हम यहीं से एक्सक्लूड कर देंगे उसको। It is an admitted case, I suppose.
It is an
admitted case है, तो it has that much liberty I grant. And then proper inquiry होगा, सब कुछ होगा, जो भी होगा होगा। Following the procedure and terms and conditions of the deed also has to be seen, which is not on record. ये तो लाए नहीं है record पर।
But this so-called they were happy that I have admitted that I have constructed.
नहीं, वो सब कुछ नहीं, वो सब admission का। सर वो admission का कहानी खत्म हो जाएगा। नहीं, any observation made in any order with regard to admission otherwise also, that will not operate. You have to do your needful as per law. होनी चाहिए। जो भी होगा उसके लिए आपको fresh proceeding initiate करना पड़ेगा। उसमें भी अगर फिर ऐड करके 12 years पार हो जाएगा तो वैसे ही खत्म हो जाएगा। यही कर सकते हैं ना? हाँ, जजमेंट्स हैं। You see, there is a gray area, है ना? लेकिन इसमें एलिगेशन ये है कि जब इनको परमिशन दिया गया था ना, उसी समय से फ्रॉड का एलिगेशन है, ठीक है? कि जमीन एप्लीकेशन देकर, जमीन लेकर ये जो है इसको इस तरह से कर
रिपोर्ट आया हुआ है कि फैक्ट्री चल रहा है,
वो रिपोर्ट आते रहेगा, उसका क्या करें हम लोग?
अरे मतलब कहने का है तो प्योर फ्रॉड तो है ही है,
वही का पर्पस से की दी गई
पर्पस
परमिशन नहीं था। आज सुपर हम कहीं एडमिट नहीं किए हैं कि हमको
घर बनाने का पर्पस तो नहीं,
घर बना नहीं जो बोल रहे थे आप जो एडमिट जो लिखे हैं आपका
उसका जो होगा 49(5) में बोलिएगा, वो देखा जाएगा। यही this would be, this is maximum we can do, like heard the learned counsels appearing on behalf of the parties. This writ petition has been filed for the following relief. बस आप ऐसे फ्लाइंग एडवोकेट बनिए, जब बहस होता मत आइए, आपकी मर्जी आप जाइए, बट दिस इज नॉट अ प्रॉपर कंडक्ट. जब केस टेकअप होता है, यू आर नॉट देयर एंड योर जूनियर इज एब्सोल्युटली क्लूलेस, जिसको कुछ नहीं पता. ये सही है भाई? अपने जूनियर को ट्रेन करिए, आपके पास टाइम नहीं है तो. यहाँ पे ट्रेनिंग सेंटर है, हम लोग ट्रेनिंग सेंटर खोले. चेंबर में ट्रेन करिए अपने जूनियर लोग को क्या क्या बहस करना. आप जाइए, वो कोई बात नहीं है तो लिखा, लेकिन दिस इज नॉट प्रॉपर ना. केस जब टेकअप होता है, यू आर एब्सेंट. This petition has been filed for the following relief. The learned counsel for the appellant has submitted that, of the petitioner has submitted that the core issue involved in this case is the only surviving point which remains for consideration by this court is as to whether the proceeding initiated under section 71 capital A of Chotanagpur Tenancy Act was at all maintainable, or the remedy was under the provisions of section 49 within bracket 5 of the Chotanagpur Tenancy Act. By giving the foundational background of the case, he submits that admittedly the property is covered under section 49 and it is a Buyari tenure. And with respect to transfer of such property, there is specific provision mentioned therein, and required permission is taken from the competent, permission is required to be taken from the competent authority. The learned counsel submits that in order to seek permission, one miscellaneous case number 76 of 8182 was initiated, in which
the application of Chetan Delgam.
Upon application filed by the owner of the property and after hearing, an order dated 13/2/82 was passed, wherein it was recorded that the recorded rayat had expired and the applicant was the successor and the property was not fit for cultivation. The permission was granted for transfer for use for specific purpose, that is for manufacture of tiles, which would also provide employment to 15 to 20 persons. He submits that thereafter the consideration amount was also fixed at rupees 5,500 and the deed for transfer was required to be placed before the competent authority for approval. He submits that the required approval with respect to the terms and conditions of the deed was also granted by order dated 15/2/1982. The learned counsel submits that thereafter the deed was executed and the plaintiff and the petitioner came in possession of the property.
After getting mutation, that is also there.
The required mutation was also carried out. The learned counsel submits that it is the case of the petitioner that there has been no violation of the terms and conditions, and for that he referred to the registration certificate 11995.
Yes. That is the renewal, Annexon 9 series, 9 and 9 by 1.
Registration certificate in connection with setting up of the unit as contained in Annexon 9 and 9 by 1. He submits that a petition being SAR case number
Annexon 2.
just पढ़ा नहीं रहा ना नंबर इसीलिए
SCR case number 1 by 1987-88, page 24.
SAR case number 1 of 1987-88 was initiated at the instance of the original owner of the property under section 71 capital A of Chotanagpur Tenancy Act before the Deputy Commissioner, alleging that the property was not being utilized for the purpose for which the transfer was made, and the petitioner had fraudulently and purposely obtained the permission from the competent authority for transfer under section 49 of the Chotanagpur Tenancy Act. The learned counsel submits that no inquiry on the spot was conducted and the order was passed.
Before that, we have challenged the notice before this one.
Okay, excellent. The learned counsel submits that when the proceeding was initiated, a writ petition was filed before this court. Is a corrected recording. Being CWJC number 1263 of
1987 R.
1987 within bracket R on the point of jurisdiction, and the said writ petition was disposed of by this court by the order dated 8/9/1987, stating that the petitioner should file the show cause and will be at liberty to question the jurisdiction. Consequently, the petitioner filed the show cause before the authority who had initiated the proceeding under section 71 capital A of Chotanagpur Tenancy Act, who without conducting any on-the-spot inquiry and on the basis of alleged admission of the petitioner, ultimately held that the property was being utilized for a purpose other than the purpose for which the transfer was permitted. And also recorded that the transfer itself was done fraudulently. The learned counsel submits that the petitioner had filed appeal, being SAR appeal number 6 of 1988-89, and the appellate authority confirmed the order against which revision was filed, numbered as Singhbum Revenue Revision number 157 of 1991, wherein the authority held that, revisional authority held that the proceeding under section 71 capital A of Tobacco Tenancy Act was not applicable and a remedy was available under section 49 with bracket 5 of the Tobacco Tenancy Act, and a reference was made to a judgment passed by this court reported in 1990 BLT 352. The learned counsel submits that this order of the revision was challenged by the original Rayat before this court in writ petition being WPC number 4921 of 2001 on the ground that no opportunity of hearing was granted to the Rayat, and this court by the order dated 23/2003 set aside the order passed by the revisional authority and the matter was sent to the Commissioner South Chotanagpur Division, fixing the date of appearance of the writ petitioner, who was to issue notice to the petitioners in the revision application and was directed to pass a reasoned order within stipulated time. Thereafter, the matter was heard in Revenue Revision case number 157 of 1991 by the Commissioner South Chotanagpur Division, and the authority considered the objection with regard to the jurisdiction and entered into the legality and validity of the permission granted by the additional Deputy Commissioner for transfer of the property, and held that the transfer itself was null and void, as the state authority was not competent to grant the permission. And the authority held that the transfer made under section 49 was itself bad in law. The learned counsel has referred to the Annexure 8 and Annexure 8/1 of the writ petition, which is notification issued by the government to show that the additional Deputy Commissioner was empowered to
was considered by the Supreme Court in course of hearing and held that the additional duty constitutional has been
As referred to the notification as contained in Annexure 8 and 8/1, and as referred to the order dated
March 2022.
order dated 9/3/2022.
9.
And in the said order, it has been recorded that it has been recorded as under. यहाँ पे quote कर दूँगी मैं इसे. Page number 2 उस orders. The Learned Counsel submits that the competence of the authority who had granted permission under section 49 has been set at rest by virtue of the said order, which was passed on the basis of the counter affidavit filed by the state pursuant to order dated 21/9/2021 and 28/9/2021. The Learned Counsel has also submitted that otherwise also the legality and validity of the permission granted under section 49 can be examined only in terms of section 49 within bracket 5 and the proceeding initiated under section 71 capital A challenging the permission for grant of transfer, the permission to transfer is itself not maintainable. He has relied upon the judgment passed by the Honorable Patna High Court Ranchi Bench, reported in 1990 BLT within bracket REP 352, Shri Rajendra Nath Kapoor versus State of Bihar, which has also been followed by this court in judgment reported in 2001 within bracket 2 bracket close JHR CR 127 within bracket JHR. Jivan Lal versus State of Bihar and others. उसका लिखिएगा पैरा नंबर 13 पहला वाला जजमेंट का और दूसरे वाले का लिखेंगे पैरा नंबर 14. The Learned Counsel for the petitioner has submitted that the challenge by the original Rayat was in connection with fraudulently obtaining permission for transfer. And such challenge to permission can be done only by the competent authority in terms of section 49 within bracket 5 of the Chutanagpur Tenancy Act, and therefore the entire proceeding initiated under section 71 capital A of the Chutanagpur Tenancy Act is without jurisdiction and is fit to be set aside. The Learned Counsel, appearing on behalf of the respondent, has submitted that there was enough material on record to prove that the petitioner had constructed a house or building over the property and had violated the permission granted under section 49 of the Chutanagpur Tenancy Act, and therefore the proceeding under section 71 capital A seeking restoration of land obtained by playing fraud was maintainable. The Learned Counsel has also submitted that as per the counter affidavit, a Bull factory was established in the name and style of Suman Bull Factory, manufacturing tobacco, which was also in violation of the terms and conditions of the deed. The Learned Counsel has submitted that the Deputy Commissioner as well as the Rayyats both have the jurisdiction to proceed against the petitioner under Section 49(5) as well as under Section 71 capital A of Tobacco Tenancy Act. He has also submitted that under Section 49(5) there is a limitation of 12 years from the date of transfer, and the proceeding was initiated within the original Rayyat had initiated the proceeding within the period of 12 years. And if this court chooses to interfere on the point of jurisdiction, the right to take steps in terms of Section 49 within that 5 may be kept intact. That's all. हम लिखा दिए आपका उनसे वो तो चले गए, जो हम लोग का सबमिशन था लिखा दिए, ठीक है. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the sequence of events as narrated by the learned counsel for the petitioner is not in dispute. Further, the transfer deed whose terms and conditions, in connection with which there is allegation of violation of terms and condition, has also not been placed on record. However, this court finds that after it is not in dispute that the transfer was made after getting permission under Section 49 of the Tobacco Tenancy Act for the purposes of manufacturing tiles, which would have also generated employment for 15 to 20 persons, and the deed was also, and the terms and conditions of the deed was also approved by the additional collector, additional deputy commissioner. A counter affidavit has been filed by the state, by the circle officer.
Yes.
By the circle officer, stating that the additional deputy commissioner was competent to grant sanction, which has been taken note of by this court by passing the order dated
9th March.
9th of March 2022. फाइंडिंग नहीं रिकॉर्ड किया है. However, no specific finding has been recorded in the said order. This court also finds that the allegation which was levelled by the original Rayyat was that the permission to transfer under Section 49 was itself fraudulently obtained and the original Rayyat had initiated the proceeding under Section 71 capital A within the period of 12 years from the date of grant of permission, from the date of transfer.
Yes.
The petition was entertained and the petitioner has been contesting the point of jurisdiction, and the matter has ultimately travelled before this court, and this writ petition remained pending after being admitted for finding. This court finds that in the judgment passed by Honorable Patna High Court, reported in 1990 BLT REP 352, it has been held that the scope of section 71 capital A and 49 within bracket 5 are completely different. The former speaks about fraud on the transferor Rayar, whereas the latter speaks about misrepresentation or fraud on the Deputy Commissioner. The court has also held that in section 49 within bracket 5, the reference is to subsection 1 and 2 of section 49, whereas in section 71 capital A, section 46 has been specifically mentioned, and that the general rule of interpretation of statute is that special provision will override the general provision. The court has ultimately held that when there is a specific provision for annulling transfer made with the consent of the Deputy Commissioner, recourse must be had to that, and an application under the general provision, that is under section 71 capital A of the Act, is barred. And admittedly, the forum under section 49 within bracket 5 and 71 capital A are also different. This court finds that in the present case, the allegation has been levelled that the permission to transfer itself was fraudulently obtained, and section 49 within bracket 5 provides a specific remedy where the state government, either on its own motion or on an application filed by the Rayat, can initiate a proceeding and conduct inquiry and pass appropriate order. If the permission is fraudulently obtained and if the terms and conditions of the transfer is violated, if the permission has been fraudulently obtained as alleged, then certainly the power for annulment of transfer and also the permission was with the competent authority in terms of section 49(5) of the Tobacco Tenancy Act. This court also finds that the counter affidavit which has been filed in the present case with respect to the power of the additional collector to grant permission, the same has been sworn by the circle officer,
When is due? Respond number 5.
by the respondent number 5.
Sub-divisional officer.
the sub-divisional officer,
And
Chandil.
sub-divisional officer, sir. Respond number. Sub-divisional officer, chairperson.
By the respondent number 5, who is an authority much lower in rank, and therefore this court is not inclined to give any conclusive finding with respect to the point of jurisdiction of additional commissioner to grant permission. Otherwise also, in absence of jurisdiction to grant permission, the proceeding under section 49 with bracket 5 was maintained. Considering the nature of allegation, this court is of the view that the proceeding under section 71, capital A of 2002 Tenancy Act was not at all maintainable, and accordingly, all the orders passed by the SAR officer, the appellate authority, as well as the impugned order are hereby set aside. Revisional order are hereby set aside on the point of jurisdiction. However, the fact remains that the proceeding has remained pending before one or the other authority, and the point of jurisdiction was contested right from beginning. Since the very initiation of proceeding way back in the year 1977-78, 87-88, which was within the period of 12 years, as provided under section 49 with bracket 5. This court is of the considered view that the proceeding the time which has been consumed during the litigation, right from the year 1987-88 till date, is required to be excluded by computing the period of limitation. This would be certainly by computing the period of limitation, and this would be the position when seen in the light of section 14 of the Limitation Act. However, it is further observed that if the respondents choose to initiate a proceeding under section 49 with bracket 5, they will do so in accordance with law, and any observation which has been made in the impugned orders will not prejudice either parties. That's all?
Repetition should be allowed.
Repetition is allowed in the aforesaid terms.
इस 49 फाइल में
हाँ
ऐसे दिन में कोई परमिशन देना
नहीं होता है।
चाहिए।
क्यों नहीं होता है? लोग बेचना नहीं चाहते हैं या कोई डील नहीं करना चाहते हैं।
जो अथॉरिटी है वो करते हैं।
It can be possible, no, that tribal is having some kind of commercial interest, पूरा property को कुछ अच्छा commercial interest में develop करना चाहते हैं। हाँ। डर से सब परेशान। ये आपका है सर, आपकी है। Written submission। लेकिन for the welfare and for the development.
It should be. Otherwise, there cannot be any development. So if fraudulent
चलिए। इसको not before that. चलिए अब इनका फर्स्ट अपील देखिए.
From the supplementary list at 10:30, item 2.
आपके सर अभी तक आए नहीं. On the This kind of one thing I want to know, so far as the point of interest and solution is concerned, the interest and solution has been awarded by your officer only. How do we undo that?
What is law?
No.
And I am not against solution and interest. I myself said
No,
that
even they have provided it right from the date of notification.
they have done it, but this is wrong leadership.
No,
Their
they
part
did
was
not.
wrong. And because leadership had asked me regarding interest and solution that day, yesterday. From where it has come, there was a notification where the central government itself provided. And this was the judgment of division bench. There elaborately it has been held that there is no provision under CBA for grant of solution and higher rate of interest. 25% is there. However, in para 16 it has been held. Considering that notification issued by the central government. That was a pertinent question by my leadership yesterday.
Para number?
Para 16. The entire issue is that solution and interest. Para 16. इससे होता है enhanced compensation of 12% नहीं रहेगा from a particular date अगर उसके पहले का acquisition है and further 9% 15%
तो इसमें एक्विजिशन कब का?
इसमें 89 से मेरी नोटिफिकेशन आया था that is
So 81, 82 को भी दिया है solution and interest. You see, we cannot reduce the amount which has been awarded to them by your authority, by their own wisdom. And ये जो mining होता है ना, ये ऐसा नहीं है ना कि एक दिन में possession ले लिए, पूरा boundary बना दिए. It is not like that. A person जिसका land acquire हो चुका है ना, उसके लिए वो मट्टी की तरह है. It is of no use to him. He is living there, it is okay. It is for you to take possession. There is a concept of deep possession by virtue of the notification. कोई हाथ में थोड़ी उठा के लेके चल रहा है, movable property है.
नहीं उसमें कहते हैं जहाँ
Did they register possession ever?
It is an admitted fact.
Admitted
Admitted it since 1996.
You see, your authority has granted interest from the date of notification.
That is not disputed. It is there. They have
We are not going to entertain this.
However, the act says that may be recorded in my patent.
Yes, everything will
And the
be
judgment stand.
Yes,
provision
certain.
that I have.
इसमें कोई doubt
लेकिन
नहीं.
interest में जहाँ पे date of the possession is not clear, तो just from the date of acquisition ये लोग दे देते हैं. यहाँ पे it is an admitted fact that 19 they themselves admit that 95
Did you challenge the quantification made by your officer on this ground that he has wrongly given it?
No.
ऐसा तो कोई आपका contention ही नहीं था. Otherwise, you could have also challenged it. That why are they giving this interest and solution? And interest, solution and additional compensation. तीनों दिया है. All the three has been given.
Statement says it is additional to नहीं about 9% and 15% it has come from 1980.
Additional नहीं होगा कहाँ होगा?
उसी paragraph के last में.
Read it please.
From the aforesaid letter of the central government exhibit, this is at page number, internal page number 8.
8. हाँ internal page तो 8 होगा.
ऊपर जहाँ SCC ऑनलाइन
अच्छा internal page. Yes. Yes please.
Shall I read this entire paragraph?
No, you just tell me where, whatever it is, in whatever manner you want.
From the aforesaid letter, this letter is that has been mentioned in para 16, जहाँ 35 लिखा हुआ. para 16 just a page prior to
ठीक है.
that, page 7.
Yes, yes.
In that regard, the opposite party has filed letter number such and such dated 12/5/89 of the Government of India, Department of Coal, Ministry of Energy, addressed to the Chairman, CIA, Exhibit H. The said letter contains a decision in respect of payment of solatium, interest and additional compensation. As regard payment of the solatium and interest, it is stated as follows. A. Solatium in addition to the market value of the land at the rate of 20% of the market value for all acquisitions made under the CB Act. B. An interest at the rate of 9% per annum for the first year and 15% per annum for the subsequent years on the amount of compensation including solatium so calculated for payment of the land loan. So date, again that what the provision says from the date of possession, that has not been touched here. It would thus appear that so far payment of solatium and interest at the enhanced rate is concerned, the state is without any ifs or buts and are made admissible in respect of all acquisition made under the CBA Act. But so far payment of additional compensation at the rate of 12% per annum is concerned, it is stated in Exhibit H that the same would be admissible in case of acquisition made under the CBA Act only where the notification under Section 9(1) of the said Act has been issued on or after 30/4/1982. From the aforesaid letter of the Central Government Exhibit H, it is, in my view, evident that solatium and interest at the enhanced rate are admissible in case of all acquisitions made under the CBA Act irrespective of the date of notification under Section 9(1) of the Act, but additional compensation at the rate of 12% per annum is admissible only in respect of those acquisitions in respect of which the notification under Section 9(1) of the Act was made on or after 30/4/82. In the present case, notification under Section 9(1) was made on 30/4/1982, and as such, so far as the claim of additional compensation is concerned, the same is clearly not admissible.
And here the date of notification is 28. So it is.
Solatium and 9% interest and 15%.
नहीं दिया क्या है? दिया तो आपको additional भी है.
इसमें दिया है.
In your case, additional has also.
Escalation.
You see, so far as the rate chart is concerned, you see the rate chart, page number 4. In addition to rate mentioned above, solatium at the rate of 30% on the land value, interest at the rate of 9% for the first year and 15% for the subsequent years, has also been paid to the claimant on the rate as indicated above, and additional compensation as escalation at the rate of 12% per annum from the period from the date of publication of notification 4(1) of the Act under Section 9 of the Act has been awarded on the rate compensation. So for additional compensation at the rate of this is by way of escalation. Additional compensation is paid by way of escalation.
30% escalation to इसमें लिखा है.
30% is not escalation.
Solatium at the rate.
Solatium is not escalation.
It is not escalation.
So this is 12% escalation per annum, and for a limited period from the notification under Section 4(1) to the notification under Section 9. 1 साल का है. It's not much.
That's not much. But this particular thing, 9% and 15%, that is beholding the provision. The Act itself says it is from the date of possession. That has to be. And prior to that, and for the enhanced compensation, that has to be paid. For that provision, 28 is attracted. Therein it says from the date it has been enhanced.
But certainly you did not challenge the quantum and quantification.
The entire thing is under challenge. The amount itself is under challenge that 600 flat rate would not have been given. With whatever the solicitation, escalation and everything. So in totality it is under challenge. Maybe some wrong has been committed by the officers if they have calculated, but when it has to be seen by this honorable court, which can see the law, which can see the records, which can see the facts, everything can be seen. So as per the law itself, it is quite clear regulation that it has to be paid from the date of possession. And any wrong committed by the court below or by the officer or by the claimant, that has to be seen by this honorable court, being the first appellate court.
Okay. Land Acquisition Act.
And in all those cases where date of possession is not clear, it has been given from the date of acquisition, the notification. Here there is a positive finding, the admission on their part.
What is the notional date of possession as per the Land Acquisition Act? वो CP Act दीजिए तो The statutory interest under CPA Act is under section
17. 17, yes, section 17. And third is section 17(3).
It is from the time the compensation becomes due until it has been paid or deposited. That is the provision.
5% from the time the compensation
Becomes due,
until it shall have been
paid or deposited. So it is this particular compensation only, this rate of interest only which stands modified. And the central government just wanted that it should be at par, at least,
whatever.
right? The quantum should be at par merely because the acquisition is under Land Acquisition Act and the acquisition is under Coal Bearing Act. There should not be any discrepancy, and otherwise it would have violated the fundamental rights. That's
Just 5% cannot be modified, which is something is in their favor and something which is against is left behind. Either this or that. Now the law is clear
no,
that
rather this 5% is completely stands abrogated by virtue of the notification and by virtue of judicial pronouncement. The rate of interest has been substituted to be 9% and then 15%, and additionally solatium has also been directed to be paid. Now this rate etc. has gone, but the manner in which the interest is to be paid is from the date the compensation is quantified and not from the date of possession. And rightly so, in case of coal bearing, the land may remain just like that. People keep on occupying. You may not go out to evict them also. Right? There is no such law. The moment you acquire it, everybody has to go out. There is no such law. You may need it in with due passage of time, maybe after 10 years, 20 years. Your land after acquisition are just lying as it is. You do not excavate everything at a time, do you? That is why, you see, the legislature has taken enough care to ensure that it is it is not your case that you have been asking them to give and they have been resisting. That is not your case.
So as and when, because they are enjoying their land, it is not that it has been
Enjoying,
they are
they are hardly enjoying, they can't do anything with it. They can't construct a house on that. Right? They can't construct a house on that.
They use it as
They use it, that is a separate thing. But it is of no use. A land which has already been acquired, if they construct house on that, it will be of no use to them. They are just living on it. Whatever, they are just living on it. They are actually not utilizing the property to its fullest possible potential. At least that much is there. Okay. This is what you have to say, right? हाँ sir आप बोलिए.
So, what my friend is referring for of this time consideration,
Yes.
that interest had to be given on the date of position. Now, this aspect has been considered by the Honorable Court, this Honorable Court is the LPA, wherein the Honorable Court has said that on the date of notification, the interest is payable, not from the date of position. When the notification is issued, then in my humble assumption, that is the date from which the interest should be given, that is, has been decided by the Honorable Court in the APM.
Where is that?
Because we are giving the compilation of judgment in the 2002 JCR, page 130. Union of India versus State of Haryana.
वही.
Our 8, 9 and 30 is the relevant of this.
Hari.
And this has been decided by this Honorable Court, the APA, filed by the Union of India, in connection with the Coal Bearing Area Acquisition and Development Act.
Para number sir. Para number sir.
8, 9 and 30.
Para 8, 9, 30. Can you read it, please, sir?
9, 8, 9 and 30. From perusal of the accused judgment, it appears that the learned single judge discussed the entire evidence, both oral and documentary, adduced by the party, and recorded the finding that determination of compensation by the tribunal at the flat rate of rupees 1200 per dismissal was not justified. Learned single judge also took notice of the fact that the competent authority, by determining the amount of compensation under Section 13(5) of the Act, considered different classification of land as well as the prevailing market rate on the basis of transaction by Exhibit E and E1, which had taken place just before and after the date of notification under Section 4(1) of the Act. According to the prevailing market rate, the price in the year 1980 was 500 to 600 per dozen. The tribunal, on the other hand, relied upon the two transactions Exhibit 2 and 2/8, which took place after notification under Section 4 of the Act. By the said transaction, a very small area were transferred, swaying the rate in the higher side. Learned single judge therefore rightly held that the price fixed for a small piece of land cannot be criteria to determine the value of large area of land acquired. Learned single judge further rightly held that the rate of compensation fixed in respect of the land acquired in different villages, namely so and so, cannot be the basis for determination of compensation in respect of the land in village loyal. It is well settled that the market value of the land means what the willing purchaser could pay to a willing seller for the property, having regard to the advantage available to the land and the development activities which may be going on the vicinity and potentiality of the land. Such consideration must be confined to the date of notification. In the case of so and so, 95 Supreme Court, in fixing the market value on the basis of its potentiality for use for building purposes, it must be established by evidence or that the potential purpose must exist as on the date of acquisition by other possible purchaser in the market condition prevailing as on the date of the notification. A distance of constructed house or construction activity in the other similar lands in the locality for the purpose contended for or of purchase for such purposes as on date of proposed acquisition prima facie indicate that there is demand for and the possibility of the immediate user of the land, and it is reasonable possibility to infer that the required lands also are possessed of potential wealth. Therefore, the existence of demand for and market at the time of acquisition for potential use must be established as a fact from reliable and acceptable evidence on to show that if the acquired land has been thrown into the market, others would have brought it for the special purpose for the building activity, which would show the demand for and market to purchase the land possessed of potential value for the purpose of building activity at that time. On proof thereof, the land must not be valued as though it has already been built up, but the possibility to use for building purpose existing as on the date of notification must be taken into consideration. The question whether the land has potential value as a building site or not is primarily one of the facts depending upon the diverse factors as to its condition, the use to which it is put off or reasonable capable of being put, and its suitability for building purpose, its proximity to residential, commercial, or industrial area, existence of educational, cultural, industrial, or commercial institutions, existence of amenities like water, electricity, drainage, and the possibility of nature, future extension in that or the existence of or the prospect of building activities for the acquired land, or in the high uh, neighborhood thereof are the relevant facts to be taken into consideration in evaluating the market value on the basis of potential use of the land. It is true that an element of guess in an estimate would have a play in determining the market value, but the present value alone falls to be determined, and feats of imagination should not run right or travel beyond the manifest limits, nor be an arbitrary or whim of the court in determining the compensation or the fixation of the market value. The existing condition, the demand of the land in the neighborhood, and other related and relevant facts should be taken into consideration. Consideration it is determining the compensation on the basis of potential value of the land. Then paragraph 13 is also relevant in my humble submission. Paragraph 13 is also regarding.
सर आप पहले हमको वो पॉइंट बताइए. Please show me that particular finding that under all circumstances the interest has to be paid from the date of notification.
From the date of notification, not from the date of purchase.
Yes, वो कौन सा पैराग्राफ है हमको हाईलाइट करके बता दीजिए प्लीज.
Eleven members of the judgment of this honorable court, reported in year 1998, Patna, page 100.
AIR 1998 Patna.
Page 100.
Page 100.
Paragraph 11. Queries which my lord is putting to me,
Yes.
that in answer by the honorable court, in para 11. Having regard to the fact what is conflict and the law discussed here in above, I come to the following conclusions. The claimant respondents are entitled to payment of additional compensation, solitium, and 30%, that is 30% of the amount of compensation, and interest at the rate of 9% from the first day and 15% per annum from the subsequent year, has been calculated and accepted by the competent authority pursuant to the letter of the central government since the same was not challenged by the appellate before the tribunal concerned, and the same is payable to the claimant. The agreed award of the tribunal to this effect is perfect, legal, valid, and justified. The decision denied upon so and so. Besides the above, the additional compensation at the rate of 12% from the market value and from the date of notification is awarded by the tribunal. By applying the provisions of Land Acquisition Act is not legal and justified, as the payment of such additional compensation is neither provided under the Act nor offered purpose for discussion. The next point considered
इसी judgment का para 14 is also there, जहाँ 20% development cost को बढ़ा के 40% कर दिया।
This is also cold bearing.
This I was about to deny. And only 12% has been granted from the date of notification for extra compensation, not for others. 9% 15% में कहीं नहीं है, 12%.
You see, so far as the division bench judgment is concerned, the rate of solitium and interest, everything has now been settled. That is the 30% solitium. Now your only concern is solitium will not have a date, right? Solitium will be right from the date of acquisition. But so far as the interest is concerned, your case is that it will be from the date of possession.
And further development cost that has
Development cost, you say that has to be reduced.
So this judgment covers that as well. जिसमें 20% कोई भी नहीं आती, 20% को बढ़ा के 40% कर दिया।
By on what ground?
हम ground की वो land को बहुत purposes के लिए develop करना पड़ता है. The same what is there in the Land Acquisition Act. Same grounds have been taken, and from 20% that is on the lower side. So I deduct it to 40%. That will pending is same. Internal page number.
The tribunal although valued the land at the rate of by 90,000 per, but deducted only 20% on account of development expenses. You read it, please.
Page 12, page.
Yes, read it. Continue. Firstly, determination of value at flat rate is not very sound and reasonable. Could you get
The
that?
tribunal was conscious.
Yes,
The
there.
tribunal failed to consider.
The tribunal was conscious of the fact that the
The
village.
tribunal was conscious of the fact that the village where the land was acquired required huge expenses for development. In my opinion, having regard to the location of village, Kashmir, and the fact that it is separated by Damodar River, having no communication except the rate of valuation fixed by the tribunal at a flat rate of rupees 90,000 is accepted to be reasonable. At least 40% should have been deducted by the tribunal on account of development expenses. In that view of the matter, the award of the tribunal on the valuation of the acquired land needs modification accordingly. I confirm the award of the tribunal so far as it relates to valuation of the acquired land at the rate of 90,000, but subject to 40% deduction on the account of development expenses. So yesterday we pointed out that in Coal Clearing Act, there cannot be any deduction towards the development cost. Here the tribunal awarded 20%.
No, it was not my view. It was a view of a coordinate bench.
Yes.
That when there is when the acquisition is only for the purposes of extraction of coal, then under such circumstances, there is no question of any deduction of
One
that.
of the views leadership and this is the other view where even that has been. I'm not talking about 40% in this case because there is no such specification on it. Statement is given with respect to the difficulty communication.
That's right. ये हो गया एक जजमेंट आपका है दूसरा ये है और बताइए सर कोई
My submission is, lawsuit make IEC. Because my friend had argued before this court that the learned court below has enhanced the compensation without there being any materials before the fellow's due. Now, my lord, in my humble submission, my lord, there is judgment of this court, referring to the judgment of the Supreme Court 2016, wherein my lords have said in para 48 and 49 of that my lord, on case one also, the compensation.
which is that judgment?
Guess what?
Which is that judgment?
The judgment of your lordship, my lord, decided on 4 July 2025.
Yes.
In the case of Union of India versus Sita Ram Saab.
Yes.
I have given that copy.
Yes, para number?
Para number 48 and 49 of this judgment which lordship may kindly see. I am referring for lordship kind consideration. Kindly see para 48 and 49.
Yes, I'm.
In the judgment passed by the Honorable Supreme Court in the case of Saban Singh versus Collector, reported in 2016, volume 12, SEC, page 619, paragraph 8, the Honorable Supreme Court has referred to the earlier decision where it has been held that determination of compensation on the basis of case work is permissible only if relevant or sufficient evidence is not available on record. In the present case, there was no comparable rate from the side of either party, and even the documents produced by CCA regarding the classification of land did not reveal any comparison with one or the other sale deed, and the judgment only award in connection with acquisition of land in village so and so relating to acquisition of land in the year 1965 was found to be nearest evidence from the comparison, and since the acquisition of the present case is of the year 1976, the market value of the acquired land has been taken with little guesswork and slight increase. Upon going through the evidence placed on record, this court finds no illegality in comparison made by the learned tribunal with the rate relating to acquisition of land for Varsha query, though made in the year 1965, and no safety was at all placed before the learned tribunal, and the document produced before the tribunal by the opposite party appellant hearing did not refer to any sale deed at all, even to Banner so as to the basis on which the comparison was fixed by the compensation was fixed by the CCA. It was certainly open to the learned tribunal to make some guesswork, and the only yardstick which was close to the fact of the case was Exhibit 1, and accordingly this court find no illegality in fixation of compensation at the rate of 1,000 per dismiss with interest of 5% per annum as awarded by the learned tribunal. So, under this judgment passed by this honorable court is based on the judgment of the Appeals Court 2016 Supreme Court matters in the case of Saban Singh of the collector. And further, Lordship may kindly find that in this case, the learned court below, in my humble submission, the tribunal has denounced the compensation not only on the basis of guesswork. Now, here in this case, if Lordship may kindly peruse para 12 of the judgment and para 13 of the judgment passed by the learned tribunal, my lords may kindly find that what was the consideration, what consideration was taken by the tribunal in enhancement of compensation. I am referring for the kind consideration para 12 and 13. Kindly see, my lords. As documentary evidence, photocopy of the true copy of the judgment dated 31st March 1995 passed by the High Court in respect of appeal number such and such in which compensation of the land of village Layo Lio was under consideration has been filed, which has been marked Exhibit 1. In very case, tribunal has enhanced the rate of compensation at the rate of rupees 1200 per decimal, which was reduced by the Honorable Court after considering all evidences, and it was fixed at the rate of rupees 600 per decimal as flat rate related to all acquired lands of village Lio without any classification, and same rate is inclusive of the rate of the trees standing on those lands. Activity 2 is the photocopy of the certified copy of the judgment passed by the tribunal on 1st March 1994 under the Coal Hearing Area Act in respect of 16 dismissed cases related to the lands of village Parade and Daru Kasma. And after considering all the evidences including sale deeds produced before the tribunal, flat rate of rupees 72,700 per acre was granted by enhancement of the compensation awarded in respect to required land. Exhibit 2 is the photocopy of map of Mandu Anchal. We show that village Pindra, we are concerned with village Pindra, is in the vicinity of the village Parade and Daru Kasma. I have given the map of map of that village, Madu Panchal manor. It is very much clear. Then kindly see the next paragraph. It is very much clear from Exhibit 1 by 8 that in respect to the land of village Parade and Daru Kasma, rate was enhanced by the tribunal and fixed rupees 72,700 per acre. Same rate was also fixed by the tribunal in judgment and award dated 3rd September 1992, passed in reference case number 57 to 88 of 1989 in respect of land related to village Layo, and it has been reduced by the High Court at the rate of 600 per decimal by Exhibit 1. However, there is no any evidence to show that Exhibit 1A has not been challenged before the Honorable High Court and it has got its filing.
It was filed in MA. This was challenged in MA, right?
Exhibit 2 was challenged.
Exhibit 2 was challenged.
Yes.
Yes.
Not this sort.
Exhibit 2 was challenged. MA number?
Challenge.
MA number you had given the MA number.
MA number 50 of 1995.
इसका फाइल आया है क्या? मंगाए थे हम.
50 of 1995 to 58 of 1995, 60 of 1995 to 62 of 1995, 64 of 1995 to 65 of 1995. उसमें 600 का लिखा है 20% reduction.
इसमें 600 कर दिया था और उसको 20% डेवलपमेंट कॉस्ट में डिडक्शन दिया है. Reduction of 20% of development cost. 600 and reduction of 20% of development cost.
So this was required for the same notice.
Just a minute. 600 plus 15%, 20%. This was acquired by the same notice.
Same notice.
Exhibit 2.
Exhibit.
And Exhibit 2 and Exhibit 1 ultimately they land up with 600.
600.
Both of them.
Yes.
Both of them.
Yes. Exhibit 1 में that 20% deduction has continued.
Okay.
And Exhibit 2 में because it was challenged further here.
Yes.
So 20% deduction was also so.
Acquired by the same
notice.
notice.
Because I do not have the judgment, I did not see. So Latium of वो क्या
वो भी किया. आप लिख देखिए.
हम लोग ऑनलाइन ढूंढे सिर्फ डिटेल्स मिला
कहाँ से
ऑर्डर
पूरा नहीं जजमेंट्स कहाँ से.
हम लोग रेफरेंस केस डाल के ढूंढे कि इतना डिटेल्स है
वही है सेम टू सेम किया इसमें. जो उसमें है वो इसमें. जो इस जजमेंट में भी वही है. अल्टीमेटली यू विल लैंड अप विद. आप चेक करें.
Now, with regard to the interest part, my friend and argument report. Now, in my humble submission, the interest part has been taken into consideration by the local court in ALP I am referring that judgment for loss of kind consideration. Lordship in IEC.
Leadership इसको भी किस डेट से देना है वही
डेट फर्स्ट ईयर का क्या मतलब है? व्हाट डू यू मीन फर्स्ट ईयर? कहाँ से काउंट
provision
करेंगे?
से जाएंगे तो from the first year from the date of possession.
फर्स्ट ईयर फ्रॉम द डेट ऑफ पोजीशन कौन सा प्रोविजन से जाएंगे?
The provision itself speaks about that it became fell due from the date of possession. So from the first year it fell. I am reading para 35. The learned counsel.
वही मतलब there is nothing mentioned here,
It is not.
but it is in the
As
same
per
terms,
लिखा
right?
है कि provision. Learned counsel also placed reliance on such and such and submitted a grant of selection at the rate of 30%, interest 9% for the first year and 15% for the subsequent year, based on advice of central government and tribunal granting relief on that very ground was held to be justified. Therefore, in the instant case also grant of selection etc. is not contrary to the provision of law as well as to the provisions of circular issued by the Ministry of Law. Provision of circular, the circular of 1989 that I had tasted, उसमें भी just provision of law has been followed कि ये भी इसमें होगा. What the provision of law says, it is there in the Act, Section 34 and Section 28.
इस एमए के अगेंस्ट में एलपीए भी है.
Judgment which I am referring.
देखिए ये एआई हम लोग किसके कितना काम कर रहा है. एआई ही है या आई डू नॉट नो. इट इज कंप्यूटराइजेशन, नॉट एग्जैक्टली एआई.
Definitely help out because we also.
अगर आप लोग अपने पिटिशंस में सब्जेक्ट सही से डालने लग जाए ना, तो आई एम श्योर इस हाई कोर्ट का पेंडेंसी 10% कम हो जाएगा. क्योंकि लैंड एक्विजिशन मैटर्स में उसको टैग करने में 5 डेट लग जाए. करेक्ट? और उस तरह के सिमिलर मैटर्स ये पैरा टीचर्स का चलते रहता है. हर एक कोर्ट से अलग अलग ऑर्डर होते रहता है. नोबडी प्लेसेस, वो सारा टैग हो जाएगा एंड इट विल गो टू वन बेंच व्हाटएवर बी द ऑर्डर. इनकंसिस्टेंसी खत्म हो जाएगा. लेकिन सब्जेक्ट ही ठीक से नहीं डालते हैं. सब्जेक्ट ठीक से आए तो एकदम बढ़िया आ जाए, है ना. इनकंसिस्टेंट जजमेंट में बहुत ज्यादा दिक्कत. इतना पुराना पुराना एक्ट है लेकिन कुछ नया चीज मिल ही जाता है. नया पॉइंट, नया चीज एवरी टाइम. It has been dismissed. LPA was preferred by Union of India through CCA.
The LPA was preferred by Union of India, again the Solatium and the interest 9% with subsequent interest 15%. And that order has been that LPA is dismissed by this court.
Yes.
Madam, the judgment I have given for the kind suspension, not the mechanism, very several cases, several LPA, not one, several LPA was filed.
LPA number 2 of 2005 and
2 of 2005.
that's right.
I was in that case, if Glossy mechanism, the Honorable Court has said, Glossy mechanism are 3 matters. Central government has admitted that they are ready to pay Solatium 30%, and the Honorable Supreme Court of India has also granted interest at the rate of 9% per annum for the first year and at the rate of 15% per annum for subsequent year till the actual payment is made. Whereas in the Act 1957, interest payable is at 5%. This rate of interest has been enhanced by the central government by notification dated 12th May 1989. It has been observed by the Supreme Court in Civil Appeal number such and such dated 6 March 19, 2015 as under. Our attention has been drawn to a letter dated 12th May 1989 of the Government of India addressed to the Chairman Coal India Limited, the contents of which they deserve verbatim reproduction. We are aware that the amount of compensation determined for payment under the Coal Bearing Area Acquisition and Development Act 1957 does not work out to exactly the same amount as is admissible under the Land Acquisition Act. In fact, as the things stand today, the amount of compensation payable under the CA Act is much less as compared to the entitlement under the Land Acquisition Act. The disparities between the two acts with regard to payment of compensation become especially accentuated after the Land Acquisition Act was amended in 1984, providing for payment of Solatium at the enhanced rate of 30% of the fair market value of the land to compensate for compulsory nature of the land acquisition. Then B, higher interest at the rate of 9% per annum of the first year and 15% per annum for the subsequent year on the amount of compensation including Solatium so determined for payment. And C, an acceleration amount primarily to cover the rise in price of land at the rate of 12% per annum of the market value of the land for the period commencing on the date of publication of notification under section 4(1) of the Land Acquisition Act till the date of award of the collector or the date of taking possession of the land, whichever is earlier. As per schedule of the Act, payment of additional amount under this sub-clause is restricted to a maximum period of 3 years only. The Department of Rural Development, Ministry of Agriculture, Government of India have been putting pressure on us ever after the aforesaid amendment were carried out in the Land Acquisition Act 1984 to effect the corresponding amendments in the Coal Bearing Area Acquisition and Development Act 1957. Also show that all the disparities between the two acts, in as much as they relate to payment of compensation, were removed and land holders were not put to any discrimination. The central government has since taken a decision in principle to amend the Coal Bearing Act in the line of Land Acquisition Act, and necessary consultations in this regard are already on with the concerned ministries of the Government of India. It will however take some time before the proposed amendments are enacted after completion of all formalities. Till then, decision already exists today. So lithium, in addition to market value of the land at the rate of 30% of the market value for acquisition land under the CBA Act, and B, an interest of 9% per annum for the first year and 15% per annum for the subsequent years on the amount of compensation including solatium, so calculated for payment of the land. The portion of payment of excavation amount for all land acquisition under the CBA Act at the rate of 12% per annum of the fair market value of the land was under active consideration of the central government for quite some time. After careful consideration of the matter, it has now been decided that the coal companies will pay an additional amount to compensate for escalation in cost of the land at the rate of 12% per annum on the market value of the land in cases of all acquisition made under CB Act where notification under section 9(1) of the state Act is issued on or after 30th April 1982. The amount of additional compensation to the state to be paid under this paragraph will, however, be limited to the period commencing on the date of notification under section 4(1) of the CBA Act or the date of notification under section 9(1) of the same Act or a maximum period of 3 years, whichever is less. Certain cases will, however, be not reopened without the specific approval of the central government. A provision of this letter makes it abundantly clear that so far as the Union of India is concerned, it is of the view that the provisions of Land Acquisition Act should be made applicable even to the circumstances prevailing before us, that is, where acquisition of land has been carried out pursuant to another statute. This has made us revert to the special leave petition in which the petitioner had been arrayed as Union of India, though Chief of Revenue Central Coalfield Limited having its registered office at Darbhanga House, Ranchi, Jharkhand, the affidavit supporting the special leave petition does not disclose the authority which has been vested in and exercised by the persons signing the special leave petition as it should have done. Learned Senior Council states that an adjournment may be given so that the inspection should be obtained to verify the position. We do not propose to waste further judicial time, which is as it is in active authority on this issue merely because we were earlier of the view that the punitive cost would be imposed on the Central Coalfield Limited, which apart from the giving unauthorizedly filed the petition on behalf of the Union of India, is endeavoring to make a stance contrary to what has already been expressed by the Union of India. It has further been held by the Supreme Court as well. In a recent judgment, one of us also in different state officer versus such and such 2015 volume 2 had applied the rationale and content of the Land Acquisition Act, especially for payment of solatium and interest even under
So there is no dispute that you are entitled for solution. There is no dispute on that. The dispute is what would be the date. Madam, just tell us one thing. So far as the payment of interest is concerned, you have paid the amount with interest and everything. That amount has been paid. Right? Now you want that the amount now should be reduced. Right? If we dismiss this appeal on the ground that it does not, suppose we interfere and we reduce it to whatever was missed. Now the interest and solution is to be returned to you. Then what?
The amount that was paid was based on what the collector had assessed.
Right.
The tribunal.
So suppose we now hold that whatever collector was assessed was correct. So the interest, solution or additional compensation you want to refund from them. Because you are fighting for that only.
We are fighting for the amount that has been increased by the tribunal.
You see, had you, the interest, whatever interest was paid, the interest was paid from the date of acquisition until you made the payment. Correct? Till you quantify and made the payment. And at the time of acquisition, if you quantify it immediately and deposit it in the court, your interest liability becomes zero completely. So the time taken to compute and the time taken for not depositing for no reason is plainly attributable to you. You could have reduced the quantum of interest to zero. So therefore, and the Act also says that this interest, the Act, I have to see the Act also. This interest is payable from the date of acquisition. No, you see, it says that, no, subsection 3, when the amount of compensation is not paid or not deposited,
CBA.
yes,
Yes.
by this section, the central government shall be liable to pay interest thereon at the rate of 5% per annum from the time the compensation became due until it shall have been so paid or deposited.
Revision by subject to correction by regulation. This is the interest part, the 73 has been replaced with the land acquisition interest part section 34.
Not replaced, there is no statutory provision.
No, there is no start that.
There is no statute. Some parity was required to be maintained, so some circular was issued.
Adopted.
That circular has been adopted.
That circular has adopted the.
That circular is not saying from the date of possession.
It says what is there in LAR.
No, it does not. It says that in order to maintain parity, the interest and solution will be paid, and the date has also been mentioned.
Yes.
But by prescribing the date, it does not refer possession.
By prescribe, because that is clear in the Act. It's a revision of this judgment which was the senior was referring to. And that is the entry of the MA 50 that I had placed. उसके para 4 में भी which has quoted the Supreme Court judgment.
Yes.
उसमें A is with respect to solation that has been determined to be paid. B is with respect to 9% for the first year and 15% per annum for the subsequent year on the amount of compensation including solation. So determined for payment. But however, third part, now the date has been specifically mentioned when escalation will be paid. An escalation amount preliminary to cover the rise in price of the land at the rate of 12% per annum of the market value of the land for the period commencing on the date of publication of notification. So in third, where the escalation has been mentioned in 12% कब से देना है? It has been mentioned from the date of notification. The same has not been mentioned for solation or for the interest amount, 9% or 15%. There what will prevail? The Act will prevail. What the Act says that it will be from the date of possession. Had that not been, this differentiation would not have been there. There was no reason for specifying. Simply कहता 3 साल के लिए होगा, उसके beyond नहीं होगा. You decide what would be the date.
That's all.
Actually, on the last day, the tribunal had taken into consideration, like map, and I had placed the map before this was report, that by the same notification the land was required, and if you also may kindly see in the map, Pindra, my land is concerned with the village Pindra.
Yes.
Now, members, in my humble submission, if you also may kindly see, Layo is in the vicinity of the village Pindra. And thus, my friend is making submission before this was report, referring Laya in the map, that the Laya is far away from the vicinity of Loyo. I am concerned with Loyo. And the Loyo.
Loyo.
Loyo. Laya is just below that, serial number 162.
There is no serial number in your map.
मैप में लोयो जो है ये लया
Loyo.
लोयो.
So it is much far away from Pindra.
Yes, but other concerned is matters. Loyo
Loyo
is
कहाँ?
my lord, in just vicinity of village Pindra. And my lord, may kindly see
लोयो
parade.
कहाँ है? In vicinity of village पंचायत. दिखाई सर इसको फाक है.
हम जो दिए हैं,
जो आप दिए हैं वही दे रहे हैं आप.
हाँ, उसमें है, मार्क कर दो।
टाइपोग्राफिकल वो और ये का डिफरेंस।
कोई बात नहीं, वो दूसरा विलेज दिखाएंगे ना कहाँ पर है.
parade और दारू का स्वाद। One 61. First lordship may kindly see in the top Pindra.
Yes.
Then below that lordship may kindly see parade. Parade, my lords may kindly see.
परेल वो तो नीचे.
Parade.
हाँ.
Below that.
अब लायो कहाँ दिखा?
Daruka Smart just by the side of
ठीक.
parade.
हाँ ठीक.
Lordship got it, my lord. Daruka Smart. And just the vicinity of Daruka Smart, the village is Loyo.
Yes.
Yes. So
This is what she had shown yesterday.
Loyo. And the land of Loyo was acquired, and the case of Loyo was considered by the local court.
सर एक बात बताइए. दारू land of Pindra, taping, cupping, whatever taping, whatever it is. Parage, Daru Kaswar,
Ji.
and Loyo,
Loyo.
right?
Right.
Were acquired by same notification.
Yes, sir.
Is that correct, madam?
Not Laya. Laya, we are not concerned with Laya.
And exhibit 2, exhibit 2 लीजिए चाहे exhibit 1 लीजिए, rate तो 600 fix हुआ ultimately. So how does that make a difference to you?
चार्ट है, DVD है.
नहीं, rate chart से तो चल ही नहीं सकते हैं, वो तो ऐसे कहानी खत्म. Now we have to exhibit 2 or exhibit 1, both are the same 600. So it makes no difference.
Exhibit 2 was acquired by the same notification, exhibit 1 is different notification.
Yes. So
And
we
exhibit 2 was further challenged here, which went up to LPN edition.
and ultimately 600 was sustained.
20% development.
Minus 20% development.
And 50%, 15%, 9%.
9%. यही तो है.
Yes.
Development cost पे ये deduction मांग रहे हैं. So what do you have to say on the point of development cost? Arising out of the same notification, right? One matter went up till the LPA court, right? Exhibit 2, and in which 20% deduction has been given so far as the development cost is concerned. What do you have to say to this?
In miscellaneous appeal, my friend is referring the order passed in miscellaneous appeal.
Yes.
Not LP.
No, in LPA also, LPA 20% deduction has been given.
LPA में सिर्फ interest part को consider भी challenge.
अच्छा, इसमें 20% deduction है MM में? MM है.
They never challenged against 20%. We claim that interest and solation would not be applicable. So that part has been.
That has been applied. 20% deduction तो है sir.
Madam, appeal preferred by the CCL before the in that appeal, the honorable court reduced the amount of compensation of lawyer village from 1200 to 600.
Lawyer village भूल जाइए आप. ये exhibit 2, दारू कसमार and परेज.
परेज, हाँ. तो दारू कसमार और परेज, और ये जो है उस पर
इसमें 20% deduction है on development cost. क्या बोलना है आपको इसमें? ये है तो एमए दिखाइए. देखिए.
And the judgment that the receiving counsel relied upon है उसको 40% माना है.
friend is saying that the appeal is pending before the
LPA में पेंडिंग है. कहाँ पेंडिंग है? केस का नंबर बताएंगे कि ऐसे ही हवा में?
उसमें कोई दूसरे लॉयर हैं,
केस का नंबर भी तो है ना,
नंबर
ऐसे ऐसे हवा में बात नहीं चलती। इसको उसके अगेंस्ट अपील किए, इसके अगेंस्ट भी अपील कर दीजिएगा, उसमें क्या है?
अच्छा वेरीफाई कर लेते हैं।
अब तो आज तो कहानी, आज लास्ट डे है इसका हियरिंग का, थर्ड डे,
Patient hearing for last 3 days.
trying to find out if there is anything new to be decided.
The leadership that 12% has been specifically mentioned from there has to be.
That I have.
And for the rest, it has been the law has to be.
That's right. ये वाला मेरा नोटिंग था, कहाँ है सर? खोज के निकालिए उसको। हाँ।
one submission melody, एक्शन नंबर 5/2014, दो रेस्पोंडेंट थे, सोहराब मांझी और लखन मांझी, दोनों डेथ कर गए हैं। उनका लेकर है ट्रांसफॉर्मेशन
तो आप इतना दिन से क्या कर रहे हैं? कहाँ फाइल किए आप लीगल इन्फॉर्मेशन?
डायरेक्टली दे रहे थे, लेकिन नहीं दिए।
आइए कहाँ है उसका? आइए कहाँ है? लीगल हीयर की तरफ से वकालतनामा फाइल कर दिए हैं।
हम वकालतनामा फाइल किए हैं 6/2014 में।
लीगल आप जब इंफॉर्मेशन दे रहे हैं कि दो का डेथ हो गया है तो उनकी तरफ से वकालतनामा फाइल कर दिए हैं।
नहीं, ये सब्सिट्यूट करेंगे तभी तो हम वकालत।
क्यों? हम ऐसे ही ऑर्डर कर देंगे सब्स्टिट्यूशन का, क्या जरूरत है उनको बोलने का सब्स्टिट्यूशन करने की? पैसा चाहिए ना उन लोगों को कि नहीं चाहिए? कौन सा, ये कौन सा फाइल है दिखाइए। बाकी लोग तो 3 दिन से सुन रहे हैं, तो कहाँ हैं आप 3 दिन से?
हम बिहार में एहतियात में है 6/2014 में।
लेकिन बोल पहली बार है, बोल पहली बार है। यहाँ पे आके खाली अटेंडेंस मार्क करने से क्या चलता है?
सेकंड
हाजिरी
हम सेकंड बार एहतियात में कल थे और आज।
कल तो आप नहीं बोले, क्यों नहीं बोले?
कल हम फाइलिंग करने के लिए
उसी में वही बिजी रहा करिए। जब केस कंक्लूड हो रहा है तब बोल रहे हैं कि एक आदमी मर गया। बताइए, इसी पर कॉस्ट लगा देंगे आपको। बस जूनियर सीनियर करते रहिए बाकी।
वो अभी बीमार चल रहे हैं।
I'm sorry to say, he is not an advocate on record. He is not in 6/02.
You are not an advocate on record.
In the FFI. And he has just served us on petition, nothing. We do not. And
आप जब जिस केस में आप एडवोकेट ऑन रिकॉर्ड नहीं है ना, आपका कोई भी सबमिशन हम रिकॉर्ड नहीं कर सकते। ठीक है?
उनका कहना है कि 4 नंबर सीरियल 614 में सर्वे में होता है।
हाँ।
नाम इसमें किया था।
तो क्या करें? मिस्टर सहदेव महतो तो है नहीं, ये कौन है? हम तो नहीं पहचानते इनको। एडवोकेट ऑन रिकॉर्ड जब तक
ये एडवोकेट ऑन रिकॉर्ड।
Six-
6 में 5 में।
हाँ 6 में डेथ हुआ है ना,
नहीं 6 में डेथ हुआ।
6 में नहीं डेथ हुआ।
नहीं, आज में
आपकी यू आर नोबडी, यू आर नॉट द एडवोकेट ऑन रिकॉर्ड। आपका ये सब सेंटेंस हम लोग नहीं ले सकते हैं ना, कोई एफिडेविट नहीं है। यू आर नॉट द एडवोकेट ऑन रिकॉर्ड, यू आर मेकिंग अ सबमिशन व्हिच इज विदाउट एनी बेसिस। कैसे लेंगे हम लोग? ये सब चीज नहीं ले सकते।
तो 6 में इनका जो कहना है, we have substituted Govind Marandi as the he says his father's name is Mitlal Marandi, but he has given it in writing that his father's name is Mitlal Marandi. We have done it as per that.
That we have brought it on recording.
नहीं, जो एडवोकेट ऑन रिकॉर्ड नहीं है, कोई पिटीशन नहीं है, उनका कोई भी स्टेटमेंट को हम रिकॉर्ड नहीं कर सकते.
You only have to take the view of the court and thereafter make a solution.
एक छोटा सा आप लोग का सबमिशन नोट कर लेते हैं, ठीक है? थोड़ा सबमिशन रिकॉर्ड करके उसके बाद आई विल जस्ट क्लोज इट. The Learned Counsel for the Appellant has submitted that the claimants had challenged the assessment of compensation made by the competent authority, and therefore the burden of proof that the compensation was not as per law was upon them. The claimants have not produced any material with respect to the acquisition of land from the same village, and mere statement that the compensation was inadequate was not sufficient, and therefore the learned court was not justified in interfering with the quantum of compensation. The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2030, bracket close 14, SCC 50, para 9. The Council has also relied upon the judgment relied upon section 101, 102 and 103 of the Evidence Act to submit that the burden is upon the person who approaches the court, and that burden having not been discharged by the claimant, the interference in the quantum of compensation was wholly uncalled for. The Learned Counsel has also referred to the judgment passed in Civil Appeal number 2732 of 2022, para 13, to submit that even for the same locality, different market value for different land is required to be fixed. The nature of land is also required to be seen by fixing the compensation, the rate of compensation. The Council has submitted that several villages have been acquired by the same notification, and the Learned Court has referred to Exhibit 1 by 1, which is in relation to village Layo, which was not acquired by the same notification, and has also referred to the map to submit that the village Layo is much away from that of the acquired land in the present case, which is village Pindra.
There are 3 villages.
No, we have seen number of villages are there.
Not one by one village,
Exhibit 1. However, during the course of arguments and from the notification which was also shown to the Learned Counsel for the Appellant, it appeared that village Pindra, the land from village Pindra, Tapin, Parej, Darukasmar, and land of some other villages were acquired by the same notification. It also appeared that the Learned Court has recorded that the village Parej and Darukasmar was adjoining to village Pindra. The Learned Counsel for the Appellant has submitted that the land of village Parej and Darukasmar is not adjoining to Pindra, but they are Parej is adjoining to Tapping, and or Tapping on one side and Darukasmar on the other side. The Learned Counsel has, during the course of argument, has also submitted that so far as Exhibit 2 is concerned, the same was in relation to acquisition of land of village Parej and Darukasmar, and the compensation as fixed for these villages have been exhibited before the learned court as Exhibit 2. She has also submitted that the compensation so fixed was subject matter of consideration by this court in MA number वो रिकॉर्ड दिखाई ना कहाँ MA number 50 of 1995, wherein the compensation has been reduced to rupees 600 per district, apart from other amounts. The Learned Council has submitted that the same was subject matter of consideration in LPA number 2 of 2005 and other analogous cases, and the LPA has also been dismissed. The Learned Council submits that by disposing of the MA number 50 of 1995, the development cost of to the extent of 20% was also deducted. He लिखेगी, she लिखेगी. The Learned Council has submitted that be it village Parej or Darukasmar or village Loya, ultimately the compensation was fixed at the rate of rupees 600 per district. Right? Apart from the aforesaid submissions, the Learned Council has submitted that has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2009, bracket 15, SCC 767, para 22 to submit that the development cost can extend between 20% to 75%. And on the point of development reduction in development cost, the Learned Council has relied upon the judgment reported in bracket 2018, bracket close 2 SCC 474. On the same point, the Learned Council has also relied upon the judgment passed in FA number 71 of 2015, para 38. इसमें भी development cost है? In civil appeal mentioned above, there also there has been deduction on account of development cost to the extent of
The principles of development cost will be discussed in para 11.
And the principles of reduction on account of development cost has been mentioned in paragraph number 11.
One more judgment is 40% enhanced कर दिया गया, that is AFO number 135 relation has that of Patna High Court of Justice MI Union versus Kashinath High Court.
The Learned Council has also submitted that in
The senior council had relied on that judgment in a case.
yes, the Learned समझ गए. The Learned Council has also relied upon the judgment in the case of Union of India versus Kashinath High Court reported in 1998 SCC online Patna 186, para number 14 to submit that in the said judgment the development cost was enhanced to the extent of 40%.
And that is related to CDN.
And the same judgment is related to the same act under which the acquisition involved in the present case has been made. The Learned Council has then submitted that so far as the oral evidence is concerned, nothing much is to be placed except to the extent that PW1 at para 5 and PW2 at para 3 have stated that the physical possession of the property was taken only in the year 1996. The Learned Council submits that even if the interest is paid, then also the interest is payable payable and referable to 1996 and not from the date of acquisition. It has been submitted that the claimant, having remained in possession, have enjoyed the property and therefore they are not entitled to any interest. And that is enough.
The same is governed by the provision of land acquisition.
Okay, the Learned Council submits that the payment of interest is governed by the provisions of Land Acquisition Act and as referred to section 28 and 34 of the 28 and 34 of the said act to submit that interest is payable only when the possession is taken and compensation is not paid or deposited. That's it. और तो कुछ नहीं?
लैंड एक्विजिशन एक्ट का प्रोविजन इसलिए अप्लाई होता है
ये वो हो गया।
हाँ, 1984
Ah, that is. The Learned Council has also submitted that the aforesaid provision of Land Acquisition Act, aforesaid provision of payment of interest under Land Acquisition Act 1894 became applicable to the Act of Coal Bearing Act only by virtue of the notification issued by the central government to maintain parity in the matter of payment of compensation, interest, solatium and additional compensation. The Learned Council, appearing on behalf of the respondents, has opposed the prayer and has submitted that and has relied upon the judgment passed by this court in FA number 140 of 2016, para 48 and 49. To submit that in case where no sale deed with respect to the same village is available, the sale deed of adjoining village can certainly be taken into consideration and some amount of guesswork is permissible in law. The Learned Council submits that the CCL had not produced any sale deed and even the rate chart does not refer to any sale deed. He has also submitted that the rate chart exhibit D was referred at the stage of the argument before the learned court. ये सब सर रिकॉर्ड से लिखा है. Stage of argument नहीं वो exhibit हुआ. The Learned Council has submitted that mere rate chart by itself cannot be said to be an evidence for the purposes of fixing of compensation, and the exhibits, either exhibit 1 or exhibit 2, where same rate of compensation was fixed, that is at the rate of 600 per decimal, and in the impugned judgment also the rate of compensation is at the rate of 600 per decimal. The same does not call for any interference, particularly when the land involved in exhibit 2 and the land involved in the present case were acquired by the same notification and at the same time. The Learned Council has also submitted that the payment of interest and solatium also does not call for any interference, and the same is referable to the date of notification or the date of notification under section 9 of the Wool Bearing Act. The Learned Council submits that so far as the notification circular issued by the central government is concerned, the same does not refer to the date of physical possession of the property. He has also submitted that as per section 9, the possession of the property vests with the coal company upon issuance of notification under section 9. And the coal company acquired the status of a lessee, उसमें है section में, under the government. That's all.
वो additional compensation में 23(1)(a) में है, वो नहीं मिलता है. That is in this case only. If you lordship sees in the note of report, the order dated 19/8/2018. They claimed it was negated by a detailed result. 12% additional compensation under 23(1)(a). But that circular did not make 23(1)(a) applicable to the CBI applications.
तो इम्प्यून जजमेंट में नहीं है.
जजमेंट में नहीं है, लोअर कोर्ट रिकॉर्ड में ये ऑर्डर शीट है 19/6/2018.
The learned, in response, the Learned Council for the appellant has submitted that while order dated 19/6/2018,
So taking a printout of that order separately.
19/6/2018 दिखाइए. यहाँ पे तो 19/6/2018. 19/6/2018, the Learned Court had, by a detailed order, rejected the claim for
Additional compensation under section 23(1)(a).
additional compensation under section 23
A of the
1 capital A
Yes.
of Land Acquisition Act
And section 23(2) of the land acquisition.
and section 23 within bracket 2 of the Land Acquisition Act. The Learned Council submits that the Learned Trial Court has not granted additional compensation.
Yes.
नहीं दिया है ना?
नहीं क्या लेकिन डिग्री में add कर दिया है.
But in the decree, the additional compensation has also been added. He submits that the entitlement of an additional compensation is also required to be decided.
Also regarding circle rates, also one judgment gets cited 20
Yes.
for SSC only.
The Learned Council has also referred to the judgment passed, judgment reported in
2024 SSC
2024 SCC on line
1691.
1691, para number
14 and 43.
14 and 43. 1691 है कि 16 है?
1691.
1691. Para 14 and
43.
14 and 43 to submit that the circle rate can also be considered by giving compensation.
By making marginal addition.
By making marginal
When no direct evidence.
marginal
Additions.
addition.
And Lordship also passed a judgment in this case, if a number from 92 of
100 attested together. उसमें same case 113.
The Learned Council has relied upon the judgment passed by this court in FA number
492 of 2013.
492 of 2013, paragraph number
113 paragraph.
para 130. To submit that the
Compensation can be determined on circle rate on estimations.
to submit that compensation can also be determined on circle rate, and that could be a basis for guesstimations. Concluded? जितना है
Last might be avoided from Krishna Kumar was the conclusion of the that was cited in that.
कौन सा
वो Krishna Kumar versus Union of India. जो
किसमें साइट
केस मत जो 492 बोल रहे हैं. Leadership ने यही उसी को कंसीडर किया है. My lord, that taking into consideration.
गेस वर्क परमिसिबल है बट ऑन सम बेसिस,
Some basis.
हवा में नहीं हो सकता।
हाँ।
चल डन। ये सब एक साथ टैग कर लेते हैं। जो रिकॉर्ड मंगाए हैं ना सबका लास्ट का जजमेंट उसको डाल।
ये
हंसी